All right, guys, I just want to quickly go through a concept that we dealt with yesterday. We basically were saying that the three rabbis were taking the case in Bechoros 28b to say that if judges created a ruling where they said that which was liable is not liable, or that which was not liable is liable, or that which is tameh is tahor, and that which is tahor is tameh, it ends up costing one of the litigants money, whether it's the plaintiff or defendant, depending on which order it is. And at the end of the day, they were using this to show that causative damage is what allows the judge who issued that ruling, out of the three, there's probably a head judge, has to pay back with his own funds, because you cannot reverse a halachic ruling. So therefore, if the one party got money when he wasn't supposed to from the other party, restitution would need to be made by the judge. This is with and Rav Abai, Rav Chanina Bar Papa, and Rav Yitzchak Nafcha were sitting in judgment of the informer, and basically said that we learn from this that an informer too that gets Rabba Abbas Soka dormant confiscated by the king's officers have to pay on this very basis that judges have to pay, because both of them are causative nature. In other words, the verdict of the judge, the wording of the informer is what causes this loss, and restitution has to be made. And that's a proof that we judge the laws of Garmi causative damage. And Rav Ilya said to them that Rav doesn't agree, that we only found it in our Mishnah. And our Mishnah in Bava Kamma is saying that basically if if the field was taken on account of the robber is obligated to provide the owner with another field. And this Mishnah has been established as speaking of someone who showed the field of another to extortionists, and this teaches that one who causes confiscation of his fellow's property is liable. So we learn it from our Mishnah, not Bechoros 28b. So how does Rav interpret Bechoros 28b about the judge having to repay? He said in any one of those cases, what happened is that the judge took a physical action to back up his wording. So in other words, if he deemed that the plaintiff should get money from the defendant, he handed over the money to the plaintiff physically. Or if the plaintiff wasn't meant to get paid and the defendant should have gotten his deposit back, it was the judge who handed the deposit to the plaintiff. So either way, the judge himself was involved in a physical action that backed the causative damage. And the same thing with pure that was impure and impure that was pure. They were mixed together in the judgment. So it was a physical action in addition with a halachic rendering that created the problem, not just the causative damage by the word alone. So that's the first concept that we learned yesterday. Guys, I took a whole big thing and I made it as concise as possible. Okay? Then the second issue is that we talk about a silver cup that was deposited for safekeeping with the custodian. And thieves came and threatened to beat him up or kill him. And he gave it to them and he saved himself. And the case came before Rabba to be judged. And Rabba exempted him from paying. And Abiah said to Rabba, but this person is one who saved himself with the property of his fellow, who should be liable to pay. Which basically means, if we learned in the first part of the 117th daf, that if you save yourself with somebody else's property, okay, you can do that, but then you have to pay back to make sure that restitution is made. We're not saying you can't, you've got to give up your life for somebody else's property, but you have to pay them back. Now, Rav Ashi later explained Rabba's rationale, and he said, listen, it's all circumstantial. When you examine the circumstances, if the custodian is a wealthy man, we assume that the thieves came with him in mind, and therefore, since he has money, but he offers the property of the depositor, he's liable to pay. If, however, the custodian is not a wealthy man, and they know about the silver cup, and that the original owner is a wealthy man, and they had that in mind, the custodian doesn't have to give up his life in order to protect the objects he's looking after, nor is he held responsible. Particularly, there's no question if there's an unpaid custodian, because he's doing the guy a favor. What would you end up landing up in court for if you're doing somebody a favor and you're not getting paid for the job? But even if you're getting paid for the job, you take a shavua, an oath, and in that case, they made up their mind that they were going to take it one way or the other. So, in other words, they wanted the silver cup. They weren't interested in the custodian or his money personally. He was in the way. And since their objective was the cup, he's not considered to have used the money of his fellow to save his own money himself. So, I mean, it's praiseworthy, according to Rabbah, that you don't sacrifice your life to save the money of his fellow. There's no such obligation to pay under those circumstances. There was an issue with the Rishonim. If you remember, the Rif ruled that this person is liable, and it agrees with the buyer, even if it was the custodian. And Rabbeinu Shonanel ruled him exempt. And Rav ruled that since the thief's objective was to obtain the cup, the custodian is exempt, even though he physically handed over. And that's the unique part, okay? Because generally when there's a direct action on behalf of the Jew to hand it over to the extortionist, he's seen as having stolen it himself physically. It's not as if he told him where it was. So likewise in the case in the dispute, since the extortionist first said that they wanted this particular property, he is exempt because he handed it over. It's not as if he did it. It was almost like they had their eyes on it and the money was burnt, as it said in the previous price. Meaning the fact that he handed it over wasn't out of his own volition. And it wasn't as if he took it to the extortionist either. Also, Tosfot is basically saying that there is different sort of obligations to a custodian compared to just want to get out of trouble and get another Jew involved in your sort of trouble. It's different. It's different here because they came upon a custodian. It's not as if you got involved in the matter that had nothing to do with it. So that's one of the considerations. The other incident, guys, the last one, or the second last one, is it was talking about the redemption of captives. So it said that there's a treasurer and he's in charge of the fund on the town for redeeming captives. And what happens, people hear he has the money, so they actually capture him. And they say, you give us the money or we'll kill you. And when the case came before Rabbah to be judged, he basically exempted the treasurer or custodian of the money for the redemption of captives. Why? Because, well, firstly, before we go through why, a buyer naturally doesn't agree. They're always on opposite ends of the case and says, it's all very well he paid, it's fine that, but he has to pay it back because if you save yourself for the property of your fellow, you have to pay back. And Rabbah said to him, listen, what was the point of this money? Kevin, the whole point of this money was in order to redeem captives. This money was used precisely as intended, therefore he need not repay, because he was a captive, so it's fulfilled its purpose. There is an exception, and one of those exceptions is if the money was used to free a particular captive, and that captive doesn't get free, the person that was free as a result of giving the captivity money, the slush fund, has to pay back in order that this other Jew doesn't lose his life or remain incarcerated. Okay, but that's the circumstance. And there's also circumstance for what if he's wealthy? Why doesn't he pay back? Well, we're saying at the time that he is basically kidnapped, he doesn't have access to bank cards, assets, etc. So he's no different to a poor person or an indigent person that hasn't got the means to rescue themselves, and therefore he's classified as poor, and therefore used the money to redeem himself. So that's reasonable. Obviously, the right thing to do, even if that is the halachic ruling, is if you are a wealthy man to have a bit of derech eretz and replace the fund. It is the nice thing, by the way. But there's a difference between what is halachically correct and what do we deem to be the gentlemanly, the derech eretz thing to do. There was one final incident or case, And we said, listen, there's a certain person who hurried and brought his donkey on a ferry boat before the people boarded the vessel. Why? Because he knew that if he would rock up late with the donkey, what would happen is they would say, nothing doing. You've got to leave. We're not having a donkey on board that goes from side to side and is uncontrollable and can tip or capsize the ferry boat because its weight is unevenly distributed, because passengers tended to divide themselves according to their weight. So if you were the size of Jabba the Hutt, you were on one side and two skinny guys were on the other side. But with this donkey thing, the whole reason he came early was because he was taking chances. Anyway, it was perceiving this danger of everybody drowning, because it's not like today where they go for swimming lessons. In those days, it wasn't a big thing. So what happened was there was another Jew that perceived the danger, came and shoved the donkey of that first person, threw it into the river, and the river drowned. And he saved the boat and all its passengers, because you must remember, you're not only saving passengers' lives, you're saving the value of the boat. And this Jew came before Rabba to be judged, and Rabba exempted him from paying for the donkey. And the buyer said, okay, I get that, but if we learn from our Mishnah, if you save yourself with the property of your fellow, you should be liable to pay. And Rabba said to him, listen, look at the context. From the beginning, this person, the donkey owner, was legally regarded as a pursuer. And it's entirely permissible to destroy a pursuer's property in order to thwart him. Therefore, the one who threw the donkey overboard is exempt. And we know this because of the fact that the donkey owner was the first one on and was taking chances. That's why the Gemara added that detail. And the Gemara provides the basis for Rabba's ruling. And Rabba follows a consistent opinion elsewhere. Okay. And just to go through this, we learned this, Gavin, in 74a on Sanhedrin, Rav Simcha's house. So a pursuer, a roidev, is the legal designation for one whose actions stand to bring about the demise of his fellow. So Jew A is chasing Jew B with a knife, and the life of a pursuer is forfeited. In other words, anybody that's viewing the situation can kill him to save the life of his victim. Obviously, the pursued can, if he manages to defend himself by killing the pursuer, is able to do it. But any witness that can circumvent this process of the victim being killed by killing the pursuer is entitled to do that. And that was in the 73rd daf in Aleph of Sanhedrin. And then this issue carries on in the 74th daf as well. So from the moment the owner of the donkey brought the donkey aboard the ship, endangered the lives of his fellow passengers. Since the ship was not fit to carry the animal at all, and therefore this pursuer is classified as a case where anybody can actually kill him, by the way, if he was the one causing it. But it might be a bit far of a stretch since he didn't have a knife, but you can certainly destroy his property because the property is what's creating the risk in order to rescue the victims. So the one who drowned the donkey was entirely within his rights, and therefore, according to Rabbi, is fully exempt from paying for the donkey. Now, if you bring a donkey on a boat fit for transporting such animals, and the donkey becomes wild and threatens to capsize the ship, and the passengers throw the animal overboard, in that case, they must reimburse the owner because the ship was built for it, and it's not regarded as a pursuer. Because although but you say maybe the animal later became wild, but it's not the owner's fault. He's blameless. He couldn't have foreseen a change of behavior. So since he's not a pursuer, or he's not partly to blame by bringing it on the wrong vessel that isn't equipped to deal with animals, it's not something he could have foreseen. And since he's not a pursuer, his property is not forfeited, and they may save themselves by destroying his property. But in that case, they must pay because he's not part of the problem. Okay. Now, if you look at Rabba's reasoning expressed elsewhere, It said, if a pursuer was pursuing his fellow with intent to kill him, and the pursuer broke some vessels during the pursuit, whether those vessels were the property of the one being pursued or the property of any other person, is exempt from paying for the breakage. Why is he exempt? Because he's liable to pay with his life, meaning he may be killed during the pursuit. So this liability exempts him from any monetary obligation incurred during that period. Okay. So let me just explain to you what we mean here, because this concept is a very difficult one to understand. I brought up with Rav Simcha, and I said to him, why is it that the person who's a criminal deserves protection from damaging the property of others? It's one thing if you're escaping from pursuit that you might damage things. We can understand maybe there's a leniency then, but this is a person that's prepared to kill another Jew. Therefore, why does he get a special exemption status for damaging the property of his fellow Jew? Do you understand what I'm saying, Kev?
He's protected.
He's protected from any damage he causes. And why? If he's the pursuer and he's the problem, why is he protected? And let me just tell you the source of this. Kim Leibadi Rabba Minay. Firstly, it's in Shmot, Exodus chapter 22, verse 10. And in Sanhedrin, it brings this pasuk, and it says, if a thief is discovered while tunneling into a house, and he is struck and dies, he has no blood. In other words, taking his life is not treated as a murder. And the reason being is if somebody breaks in your home, your adrenaline is rushing. You want to protect your property and your kids, and you don't know what this person's intent is. And therefore, you can kill him, even if he hasn't killed you first, or is not brandishing a weapon, because you don't know what he's thinking. And the reason for this law is because the thief knows that he's vulnerable and that his life can be taken. He's going to protect his life by killing the homeowner first. Do you get what I'm saying? Because it's a natural instinct for a homeowner to protect his property and not think clearly about this. So therefore, the owner may preempt him and kill him without warning. So from here we learn that if somebody comes to kill you, you've got to anticipate him and kill him first, whether you see a weapon or not. If the victim is permitted to kill the pursuer, he's certainly permitted to damage his pursuer's property. So what we are also saying is as follows, before we say about the victim. Since the pursuer is now at risk for being killed, he's treated, Kevin, like a case of, do you remember there's a case where we said if somebody breaks Shabbos and they burn the Picasso on Shabbos with warning and with witnesses, etc., he's liable to the death penalty for breaking Shabbos. But that act of breaking Shabbos was simultaneously occurred with him burning the Picasso. And therefore, he's not liable to the lesser penalty of paying for the Picasso that was burnt, because he gets the greater penalty, which is a death penalty, which atones for both the murder and the theft. Okay, so what we are saying is here is that the thief or the pursuer has got the status where it's like a person liable to the death penalty. They could get the death penalty from anybody witnessing this act and taking out the pursuer by killing him, or from the victim himself. And therefore, or even a thief that tunnels into a property, he's now putting himself at risk because the homeowner can kill him. He's now got the special status as almost having the death penalty upon him. And therefore, anything that he breaks while that duration of time occurs, while he's vulnerable at risk, he isn't responsible for, because him losing his life is a penalty for being a roidef, as well as the breakage that occurs. Do you get what I'm saying? So that, in essence, works for the thief or the pursuer in that case, that because of Kimle B'Rabamine, the law also protects him from the lesser payment, since his life is at stake. I know it's a
Can
difficult
I ask you a
concept to
question
understand.
there? 1 second question. If the pursuer goes after this, he's chasing this guy, all right, and he damages stuff along the way, but he doesn't land up catching the guy, then he hasn't, then Kibble, whatever it's called, won't take effect because he
It,
didn't kill him.
it does. It does, and I'll tell you why. We did do this in
Okay?
Sanhedrin, is that the point of it, I said to Rav Simcha, firstly, it shouldn't protect him. And who's to say, I used this case of a thief breaking into somebody's home. If you remember that Gemara talks about breaking a barrel. And we learn from Rav Simcha, if he steals it and it remains extant, he has to return it. But he doesn't have to pay the financial equivalent, according to some opinions, because but certainly if it's in existence, he has to give it back. But just talking about the broken barrel, while he's in that time zone of having his life at risk, whatever occurred during that time zone in terms of breakage is considered a simultaneous act of him being vulnerable to the death penalty, whether or not he actually died or not. And therefore, that entire time period, he's off the hook for any property damages. It doesn't extend to theft because afterwards the object is still in existence, and therefore he has to return if it's still in existence after that time period because he has possession of it. It's as if he found a lost object at that point, which he has a mitzvah to return. Do you get what I'm saying when he's no longer at risk? But there are opinions that say that if he, um, um, if if um, if it's no longer in existence for whatever reason, like that he might not even have to return it. Do you get what I'm saying? But certainly, under that point where he's got blood on his hands, not blood on his hands, where uh, he has no blood, meaning anybody can take his life, either for pursuing somebody else or for the fact that he broke in a home. Whatever he does during that period of time, Gavin, it's damage he causes, he's off the hook. You can't have Kim Labadi Rubbermin nowhere. He's vulnerable to the death penalty, and any minor damage caused under that is not covered. It doesn't work only in one particular way. It works for both cases. And also, so that's one thing to bear in mind. So, so we're saying because he's liable to pay with his life, because he can be killed during the pursuit of the victim by anybody that's witnessing A chasing B with the knife. The liability exempts him from any monetary obligation incurred during that period. And that's including if you're breaking into a home and your life can be taken. If you break a barrel, you're off the hook. And if one being pursued, Gavin, now this is the one being pursued, broke the vessel of the pursuer, is exempt from paying for the breakage. Why? Because if the pursuer's money should not be regarded as more precious as the one being pursued than the pursuer's life. In other words, what it's saying is here, Kal v'chomer, you can save yourself if somebody's trying to kill you, self-defense. And therefore you can destroy somebody's life in order to save your life that's pursuing you. You can certainly destroy his vessels without any need for reimbursement for their destruction. Do you get it? So Kal v'chomer. Now, there is a one other case. But if the one being pursued broke the vessels of any other person, for it is forbidden for a person to save himself with the property of his fellow unless he reimburses the person for his property. So we're saying there are vessels that were in the path of his escape, and he had to break them. It's fine. But that other person isn't responsible for any of this, and therefore that third party has to have his vessels replaced by the victim. And even Rabba would agree with that. But, and this is where it gets interesting, is that if you have somebody that's trying to rescue the victim by trying to disarm or kill the pursuer, then whatever he breaks in order to stop Jew A from killing Jew B, and the damage inflicted by the course of his rescue, he is rabbinically exempt. That's not based on the strict letter of the law. Gavin, the whole reason that's based is that nobody is going to try and rescue their fellow Jew if they have to have a whole legal case of damages against them. If in the act of pursuit things were damaged, do you get it? They're not going to step up to the plate. And you say, but why would they?
Yeah.
Off?
Yeah.
No, just checking. So Kevin, what we are saying is, if you see Jew A trying to kill Jew B, and you in Santon City where they've got crystals and expensive stuff, and you can basically disarm, because you're a police reservist, disarm this assailant, but you're now responsible for 100,000 rands worth of damage, you're going to not want to get involved. And therefore you're off the hook in that basis. Because it said we would find no person willing to save his fellow from the hand of a pursuer, lest he become liable for damage inflicted in the course of the rescue. So to ensure that people will not shrink from the challenge of rescuing others, the rabbis decreed that a rescuer not be held responsible for damage caused in the course of the rescue. Look, guys, at any rate, we see that rabbi holds that if one is being pursued and breaks the vessels of the pursuer in his attempt to escape, he's exempt. And this is the exact reason why Rabba based his ruling in the case of the person who threw the donkey overboard, because everybody was going to die and drown, and assets were going to disappear. So he's within his right to damage the pursuer's property in order to save everybody in the boat. And that's the bottom line. All right, let's end off today. I hope I did a good summary of yesterday.
No, it was very good.
So, Damon.
Yep.
So you say if somebody pursues a would-be killer and damages goods or damages things on the way, one of the opinions says he could be liable for that, but then it's not fair. Then, who was the opinion that he's not liable for it because you won't? Otherwise, people won't pursue justice or do the right thing.
According to all rabbinic opinions, if he's trying to disable an assailant, he's not responsible, the third party, for stopping the assailant from killing or maiming the victim, and sometimes stuff gets damaged. So the rabbis made a special decree, according to all opinions, that we don't go by the strict letter of the law in that case at all.
And is a pursuit always a positive thing? Can't it be negative when you're pursuing somebody and you're wrong? You shouldn't. You're going after an innocent victim or innocent person. Sorry.
Well, Kev, I'll come to you right now. Just one question. Well, Gavin, that's why we have police officers today in clothing, so you can check which is the good guy and which is the bad guy. So if you have a badge.
Yeah, but what I'm saying is that the pursuer, if he's the bad guy, is he still exempt from having to pay for third-party liability? That's what I'm saying.
Yes, and it's a crazy rule, it seemed, but I pushed Rav Simcha for this, but I didn't push him in it for that context. I said, how can you break into my house and you at risk at me killing you? I don't kill you, and you damage my stuff worth 100,000, and you're off the hook because of the potential that I could kill you.
Yeah, it's the same thing. Yeah.
And it's the law of cumulativity rabamine, which means while the life of the thief or the pursuer is at risk for himself being killed, any damage that he causes under that is seen as a lesser transgression. And since his life's almost at a capital offense that it could be taken, he doesn't have to pay for the lesser damage. That's cumulativity rabamine.
Got it. I just wanted to see if it worked both ways. It does.
Yeah.
Okay. Yeah.
These pursuits are never trivial.
Very funny. That's very cute.
Yeah.
Please, God, Kevin, I want you to speak for a few minutes because the recording got cut off. And you see, if you speak in the end, I know how to plan for you. So it's much easier.
Oh, yeah, I got the answer actually. I sent it just before
we say the whole thing. Say the whole thing.
Yes, I'm going to say, okay, here we go. I'm going to say the Rov one from the Ron Chabad actually answered what I said.
Yeah, but I don't want to join with the other shares. So say everything you were going to say to the group. And just one thing, may this be a dedication that the hostage get released and protected. The soldiers are protected. We smash our enemies and Hashem
Amen.
Purim redeems us, and we know it's Hashem that redeems us. No international power, no army, nothing.
And
Okay.
also comfort to the Perez family for what happened to them. All right.
So you want me to, okay, about can I just say something?
Yeah.
What I've got something else to say, actually. Or should I say what I said earlier?
Whatever you want to say, but just say it before the time runs out.
Okay, so yeah, because I'm just going a few minutes anyway. Okay, so it's basically what I said was, my question was, if we are following the Megillah reading and we miss a few words, or we maybe drift off, or we lose focus. I don't use it to drift off. We lose focus, but we know the point from where we missed off the actual section before we focused again. So I got an answer, actually, and it says here, if you miss some words, you may quickly read them to yourself from the book only during the reading, and then catch up where the reader is holding and continue listening from there. Megillah has to be read in its original order, so you cannot read a pasuk from the middle after you have finished reading. So you can't go home afterwards and read it for yourself, or even after the reading in the shul. You have to catch up during the reading. You can't do it afterwards, because it has to be read in an order. So that's I hope I explained it correctly.
You did. Arth, just before we cancel the share, I just want to see your face on the share, because everybody ever sees your cupboard. They said, is Arth the name of the cupboard you have? Okay,
There's a
perfect.
cupboard. He moved. The cupboard moved.
The cupboard
Yeah,
moved.
you happy?
Yeah. You shouldn't. Thou
back.
shalt not covet, or is it thou shalt not covet?